Welcome to Medmarc's webinar series. Today's presentation is titled Life Sciences Claims 2023, Making Sense of an Evolving Landscape. I'm Kate Klaus, Senior Attorney in Medmarc's Risk Management Department. On behalf of Medmarc and today's presenters, Sonia Valdes, Andy Hall, and Katie Stricklin, thank you for joining us. As a reminder before we begin, this presentation is for informational purposes only. In the event any of the information presented conflicts with the terms and conditions of any policy of insurance offered by ProAssurance, its subsidiaries, and its affiliates, the terms and conditions of the actual policy will apply. Joining us today from our Medmarc Claims team, we have Sonia Valdes, Vice President of Claims, and Andy Hall, Executive Claims Specialist. Together, they have a combined 37 years of claims handling experience. This year, we are also pleased to welcome attorney Katie Stricklin as a panelist. Katie is a partner with Walsworth, a California-based litigation firm. She concentrates her practice on all aspects of complex civil litigation, including life sciences, products liability, and general liability defense matters. Katie has been involved in the representation of a wide variety of clients, including premises owners, manufacturers, suppliers, and retailers. She practices in both state and federal courts and has experience with multiple party and class action litigation. Katie has participated in the successful resolution of these types of claims through dispositive motions, mediations, settlement conferences, and trials. And with that, I am pleased to turn it over to Andy, who will go over the agenda for today.
Thanks, Kate. I want to go over the agenda real quickly. And I was thinking about this earlier, and there's not a lot of positive news we're going to go through here. We're going to go through a litigation update and some major trends we're seeing. And I thought about I think it's something along the lines of local TV news likes the car chases because it gets the ratings. And I promise we didn't intend to just give negative news when we planned our presentation, but that's how it stacked up. So we'll start with Katie, who will give us a litigation update. Then I will talk to you about conspiracy theories and safety-ism. Sonia will talk to us about litigation funding. Katie will talk to us again about personal jurisdiction, and I'll wrap it up with a brief little bit about what's happening at the FDA. So with that, I can turn it over to Katie, who will give us our litigation update.
So good morning or afternoon, everyone, depending on where you're located. Next slide, please. So we're first going to take a look at some current litigation, primarily at mass tort litigation in federal district courts across the U.S. For those who may not be familiar with the acronym MDL, it refers to multi-district litigation, which is essentially a federal procedure of streamlining multiple individual lawsuits relating to a specific issue or product into a larger claim. And as shown on the slide, as of mid-November, there are close to 465,000 MDL cases. And these MDL cases make up approximately 65% of all cases pending in the U.S. district courts across the country. And 90% of those cases, of all the MDL cases, are product liability cases. So taking a look at some of the largest MDLs, first we have the 3M combat earplug litigation, which is the largest MDL in history. It currently has 286,000 plaintiffs. In August of this year, 3M actually announced a $6 billion settlement, which is intended to include all plaintiffs in the MDL. So we anticipate seeing that MDL go away in the near future. Next on the list, J&J talcum powder litigation, which still has 53,000 plaintiffs. Then we also have the CNR Bard hernia mesh litigation that has 21,000 plaintiffs. And the Zantac heartburn medication litigation still has 14,000 plaintiffs. And if you've followed this litigation at all, you may recall that in December of 2022, the MDL court, Judge Rosenberg, dismissed all of the cases in the MDL, ruling that plaintiffs could not present sufficient good science to prove that Zantac caused cancer. But plaintiff has appealed that ruling, so the MDL is still pending. We also have the Prilosec Nexium proton pump inhibitors, which has 13,000 plaintiffs. And recently there have been some settlements in the PPI litigation. AstraZeneca announced in October that it will pay $425 million to resolve claims but there are still other manufacturers involved in that litigation. And then finally on that list, we have the Taxotere chemotherapy drug that MDL currently has approximately 10,000 plaintiffs. And a couple of the fastest growing MDLs, we have the Paragard IUDs, and new cases are still being added to this MDL, and it's currently sitting at over 2,200 cases. And then we have the CPAP ventilators, which we'll be discussing a bit further in just a bit. Next slide, please. So perhaps not necessarily the largest MDLs, but we're going to talk about some MDLs to watch. And the first is the acetaminophen Tylenol MDL that's currently pending in the Southern District of New York. The prime allegations in this MDL are that Tylenol's active ingredient, acetaminophen, leads to an increased risk of prenatal exposure to both autism and ADHD. The MDL was created in October of 2022 and was initially certified against defendants at the time who were 9 retailers. One of the retailers was Walmart, and there are plaintiffs that have brought suit against Walmart for its generic brand of acetaminophen Equate. In the fall of 2022, Walmart filed a motion to dismiss on preemption grounds. And acetaminophen is regulated under the FDA's monograph system for over-the-counter drugs. So the question before the court was whether the claims against Walmart were preempted when dealing with a final monograph drug, and specifically whether Walmart could unilaterally change its label on the product without violating the monograph that was in place for acetaminophen. The judge held that the claims were not preempted, and the monograph did not prevent Walmart from adding in utero warnings to its label in order to comply with state law. Earlier this year, Tylenol manufacturer J&J filed a similar motion to dismiss on preemption grounds, which was also denied by Judge Cote. Last week, on December 7th, a Daubert hearing was held to determine the admissibility of plaintiffs' experts. And a Daubert hearing, also known as a Rule 702 hearing, is a procedural mechanism by which federal courts determine whether parties meet certain criteria governing the admissibility of scientific research and expert testimony. So as Judge Cote considers plaintiffs' critical literature investigating the link between prenatal Tylenol use and autism, she will consider several fundamental questions, including has the theory been tested, and has the theory been subject to peer review? What was the actual or possible rate of error? And does the relevant scientific community accept the theory or its methodology? So we'll be watching for Judge Cote's ruling. And currently in this MDL, there are over 400 cases pending, and that number will surely be affected one way or the other by the outcome of this ruling. Next, we have the CPAP ventilators MDL. And as of mid-November, there were over 700 cases pending in this MDL. And in 2021, Philips issued a recall of almost all of its CPAP and sleep apnea devices because of potential health risks. And specifically, it was found that the polyurethane foam used in the devices to reduce sound and vibration can break down or degrade, which can result in the foam or chemicals in the foam being swallowed or inhaled. And as a result, plaintiffs allege injuries ranging from respiratory conditions to lung disease or cancer. This MDL was created in October of 2021 and is pending before Judge Conti in the Western District of Pennsylvania. This MDL is moving much more slowly as compared to the Tylenol autism MDL we just looked at. And Daubert hearings are not anticipated until early 2025, although, of course, that can always change. With respect to the CPAP ventilators, there's a separate class action lawsuit alleging economic, or financial losses relating to the purchase or rental of the recalled devices. And in September of this year, Philips agreed to pay at least $479 million to settle that litigation. We have a couple of newer MDLs to watch. And the first on the slide is the Tepeza MDL, which was created in June of this year and is pending before Judge Thomas Durkin in the Northern District of Illinois. And Tepeza is an injectable drug used to treat thyroid eye disease, but plaintiffs allege that the manufacturers failed to warn of an increased risk of permanent hearing damage or tinnitus, which is ringing in the ears. There are currently just over 50 cases in this MDL, but it appears to be growing. And discovery looks like it's underway, but it doesn't look like any motions or bellwether trials have yet been set. Next on the screen there, we have Suboxone, and this is used in the treatment of recovering opioid addicts, helping them to avoid withdrawal symptoms while undergoing therapy to help them break their addiction. And Suboxone was originally sold as a tablet, but it was later introduced as a film, which users place under the tongue until it's dissolved. And plaintiffs' allegations in this litigation are that the manufacturers failed to warn of an increased risk of tooth decay, broken teeth, or other dental injuries. Plaintiffs have petitioned the JPML, which is the Judicial Panel on Multi-District Litigation. And essentially that is a panel of judges who determine whether or not an MDL should be created on November 27th of this year. So we're waiting to hear that decision as to whether that MDL will be created. And finally, we have the phenylephrine, and well, actually, it is now an MDL. This litigation encompasses claims against various manufacturers alleging that over-the-counter cough or cold medications containing phenylephrine as an active ingredient are ineffective in relieving nasal congestion. And these claims were filed in response to an FDA advisory committee agreeing that the products containing phenylephrine were ineffective. There was a hearing before the JPML on November 30th of this year, and late last week, the JPML ordered the centralization of these actions into an MDL, which will be presided over by Judge Brian Cogan in the Eastern District of New York. So we'll also be watching to see what happens there. And with that, I will pass it back to Andy.
All right, everybody, I'm going to talk to you about conspiracy theories and safety-ism. So this is the first of kind of our broader topics that we're going to talk about here. And I will start with a poll question that everybody can answer. And that is, which of these is the best predictor of who will be a plaintiff's juror? Political affiliation, belief in conspiracy theories, or demographics? And while everybody's voting, I will tell you that the data that I have here comes from IMS, who's a jury consulting company. And what they did recently, they surveyed 250 jury eligibles from across the United States and gave them a fact pattern. And that fact pattern was a fictional lawsuit where plaintiffs said that her migraine medicine had a carcinogen that caused her cancer. The defendants obviously said that's not true. The drug doesn't cause cancer, and gave alternative causes. They even presented some scientific data. They had the IARC, which I looked it up. This is the International Agency for Research on Cancer, which is part of the WHO, to say that it was a potential carcinogen, and then that the FDA would say there's no link that's been found, but at least in humans, between this drug and cancer. So I think if we can close out the voting now. And interestingly, before this, I would have also agreed with you all that demographics is the most important. And that's actually not true. According to this study, it is conspiracy theories, which is quite honestly pretty scary. So the study showed that belief in conspiracy theories, and they surveyed 11 conspiracy theories, and I'll go through this in a little more depth in a second. And belief in those was most likely to result in you being a plaintiff's juror. The second predictor of juror behavior was extreme sympathy and a need to help the plaintiff regardless of evidence. And that's really going to get into to me, that's very similar to the safety-ism juror I'll talk to you about. And then sadly at number 3 is the only one of these that's defense friendly, and that's called cognitive reflection, which they said is the ability to override emotion with rational thought. So to move this forward to my next slide, they tested 11 conspiracy theories, and on average, about a third of the jurors believed at least one of them was probably or definitely true, and roughly 20% of those polled believed each of those was true. And what is further scary about this is this does not, you can't easily categorize it between political or demographic lines or some of the traditional ways that we've used to look at jurors. So, I thought about this and I found in the study, because I thought this could be helpful. If you're doing voir dire, what are you looking for? And here's what they said in this article. That you have a positive view of Donald Trump compared to Liz Cheney or other moderate Republicans, that you did not get a COVID vaccine, that you distrust the FDA, the EPA, and science in general, lower education, lower income, higher religiosity, and a respect for authority. So those folks that polled it well in those categories were more likely to be this conspiracy theory juror. And what's also sort of interesting when you look at this article, and I kind of commend it to you all, is that you can really get polar opposite extremes on the political spectrum that fall within these categories, right? You can get the very, very conservative Republican and the very, very liberal Democrat, and they sort of converge in this plaintiff sphere, which is totally different than the way we used to look at these types of things. So my second type of juror is the safety-ism juror. And this has been defined as, and this is a different study, and both of these are really interesting articles to read. There's a total avoidance of risk or harm, an emotional reasoning that trumps logic or science, have a good versus evil mindset, or tribal mindset. And the article that I read traces this kind of through history, and they pointed to 3 Mile Island, which was all over the news when it happened. This is a little bit before my time, as kind of that start of that 24/7 news cycle and bringing these disasters and catastrophes to jurors. And over time, that's led to this safety-ism kind of characteristics. So these jurors are going to be a little bit different than your conspiracy theory jurors. They're going to be higher educated. They're going to live more in urban areas. They're going to be strong Democrats. They get their news through electronic means. And unlike my other set of jurors, they're more likely to have received the COVID vaccine and plan or already did get the booster. And what's also maybe further vexing is they don't distrust science. They're just more likely to distrust science coming from the government or what they perceive to be big corporations. So let me ask the second question, second poll question. Most jurors believe that a product should be 100% safe if it's on the market. Is that true or false? So I'll give everybody a few seconds to put in their answer. Hey, all right. I think I kind of led to this answer. The answer is yes. So when you look at this, most respondents, and this is a separate study or article I looked at, said companies should take every possible measure to ensure their products are 100% safe and warn about every possible risk or side effect, regardless of size. And some of these folks have already applied this to their lifestyle and not using products that have had any indication that could be a carcinogen, regardless of kind of the veracity of that allegation. So I will tell you that Sonia and Lauren and Jeff and I and everybody in claims, we've seen this mentality play out both in trials and mock jurors. We had a mock trial we held this year where a defense-friendly juror decided that a recall should be initiated for the product across the entire country because they thought that this issue was legitimate. And this is despite the fact this was the only instance the company had ever seen of this. So that shows you kind of where this is coming from. This was somebody who was more defense-friendly, but was still deciding that everybody should have their products recalled and fixed because of this one instance of an alleged error. And this is really getting into what I view this almost as like an absolute guarantee of safety. which is obviously different than kind of what the industry standard is and what the FDA requires of folks in the life sciences space. So why does this matter? Some of this may be kind of self-explanatory, but the FDA approval clearance isn't the gold star anymore. This was, gosh, Sonia, this would have been over like 5 years ago at our mock trial. At our MDS, we held a mock trial, and we had a juror who said, well, I don't really trust the FDA. They're kind of the minimum standard. I want to see products that are safer than what the FDA requires. So really, jurors are expecting more than I got clearance, I got approval, there's been no recalls, there's no 483s. They're expecting folks in the life sciences space to do that, and they're expecting more on top of that. And when you look at these kind of all this information I've given you, the jurors are predisposed not to trust corporations, and they're going to think the worst when dealing with gaps in your company's story. So I think everybody has to kind of take a look at that and maybe recalibrate both from the attorney, and I'll go through this in a second, how our defense attorneys prepare cases and for our insureds, kind of in your risk management, product design, quality assurance type process. So defense attorneys, I think there's kind of 3 big things to think about here. Focus your voir dire on finding these jurors and hopefully striking them if you can. Craft your litigation themes and strategies, kind of assuming you're going to get some of these jurors. I think statistically, it's going to be pretty impossible to get rid of everybody that would fall within one of these categories. So then you need to figure out how you're going to deal with them. And one of the things that I think you do is you deal head on with problems with the company story. I think especially in this with those conspiracy minded jurors, you need to be thinking about if there's something that I need to explain, let me do it in the opening statement. Let me do it as soon as possible so that that juror doesn't spend the first week of trial while the plaintiff is presenting thinking, why haven't they addressed this? What's the answer to this? For companies, I think there's really no simple answer here, but a few things that you should be thinking about. Understand that if you do end up in a products liability lawsuit, you're kind of starting from behind the start line here, and that jurors are going to be predisposed to have a negative view of your company. Also, that, as I said, meeting these your industry standards isn't enough. And so what I thought about this is kind of in all aspects of your design and your quality assurance and your regulatory piece, thinking through all these safety type of issues and documenting kind of your decision. And what I'm saying here is not that every time you get a customer complaint, you need to do a recall, or everything you could possibly envision needs to be in the warnings. But certainly you need to be able to document that you're thinking of these things, that you're making decisions on them, and if they are quote unquote less consumer friendly, why that decision was made. And I like to think of it as if you were being deposed at trial with this type of juror, would you feel comfortable in defending the company's actions on these issues? So it's going to be kind of a delicate balance there. So that's what I have on this section. And I believe Sonia is up next with third-party litigation funding.
Thank you, Andy. This is Sonia Valdes, and I'm going to speak to you for a few minutes about third-party litigation financing. And many folks have already have had some exposure to this. What is it? It's a term that describes the practice of giving money to a party to pursue a lawsuit in return for a share of the damages awarded or the settlement achieved. Now, third-party litigation funding, or TPLF, is not a U.S. phenomenon. Australia has had it for a number of years. It's catching on in Canada, but make no mistake, it is growing in our country. Why is third-party litigation funding growing? It is because of the increased litigation costs. It is also because of the lack of capital in traditional funding markets. And then certain professional responsibility rules, i.e., a lawyer can't pay for a client's living expenses. So I think that of the 3, the biggest has to be the increased litigation costs. What are the benefits? Well, the benefits are an increased access to the courts, increased access to justice. It is thought that plaintiffs do not have the ability to fight the big corporations, and this is a way of giving them at least some financial help to fund litigation. There are, and this litigation funding is used to fund attorney's fees, court fees and expert fees. So those are the three types that litigation funding works towards. There are three general type of funding arrangements. The first one, non-recourse loans, they're made to the plaintiffs, and what they are describing is that the third-party litigation funder is out of money if nothing is recouped. And of course, they will share, just so you know, it's about 20% is the return on investment for these third-party litigation funders. The loans can also be made to a law firm or a lawyer for complex litigation. And it could be funding a number of mass tort individuals, individuals hurt by the same product or commercial claims. So why is this a problem? It's a problem because third-party litigation financing tends to spur frivolous litigation. You know, what's the best disincentive against filing frivolous lawsuits? And that's the lose your pay system that we have in Europe and in other parts of the world. Here, you can bring an action in this country. You don't have a lose your pay, and you don't even have to worry about the investment because the money is fronted by the third party litigation funding. And so, you know, this is how you in a case that, you know, probably wouldn't be brought in Europe would be brought here in the United States. And so that's part of the problem. You're seeing a lot more questionable cases that are funded by TPLF. And what kind of cases are attractive for third-party litigation fund? Huge cases involving a lot of money, patent litigation, cases involving commercial, international, intellectual property. Not the fourth one on this list is actually products liability and including medical devices and pharma litigation. So the ethical concerns, then they are significant. Maintenance and champerty are two common law doctrines that have been abolished in England and Wales. They have not been abolished in the United States. Maintenance refers to the intermeddling of a third party to spur a lawsuit, not so much in the third party litigation funding context, but champerty hits it straight head on. Champerty refers to an agreement where a person with no previous interest in a lawsuit finances it with a view to sharing the disputed property if the suit succeeds. So you can see they've got common law terms. Under the ethical concerns, bullet 2, it's an erosion of the lawyer-client relationship. A third party, the litigation funder, has been introduced to the relationship between the attorney and the client. Many people say that the introduction of this third party has eroded completely the attorney-client privilege. Ultimately, what is affected are the confidentiality, impartiality, professional judgment, and to some extent, clients' control over the litigation. The biggest issue are impartiality and client control. The third party's litigation interest, the third party funder's litigation interest is really a return on equity. Return on investment, return on investment, not vindicating a plaintiff's rights. Thus, there are questions as to who's really litigating and who is making the decisions on behalf of the client, or in the client's best interest, for that matter. And so what has been done with this increasing problem in American litigation? Not much is the answer. Generally, the courts, the federal courts, have taken a hands-off approach. They're left it to the states. And there's really no consensus among the states on how to deal with this. A small number of states have required the registration of a third-party litigation funder. A small number of states have required disclosure of the third-party litigation funder in discovery. But the application of these curbs has not been widespread at all. It's only a handful of states that have implemented some type of control. Why is it a problem? Well, you heard Katie talk about the MDL and the numbers in the MDL, and the fact that product liability cases are 90% of the cases in the MDL, the mass tort division. Many of those cases, I remember looking at it a couple of years ago, are drug and device cases. So why is it a problem? As a result of the aggregation of many claims into a single proceeding, the exposure increases exponentially for defendants. They have to settle more than just one case. They have to settle a number of cases. And one of the principal reasons for bundling these cases on behalf of the plaintiff or the third party litigation funder is so that the defendants have to settle non-meritorious cases in order to settle the big cases, the seriously injured. They're not going to break away and settle a portion of them. You've got to settle all of them at the same time. Third-party litigation funding means no more contingency fees for lawyers. So there's less risk for them to bring frivolous lawsuits. Plaintiffs need to hold out for more money. A third reason is plaintiffs need to hold out for more money to pay the third-party litigation funders. As I mentioned, 20% is what they get on average for funding this litigation. The plaintiff has to pay the third-party litigation funder, their attorney's fees, experts, and now whatever's left over is what they get. So they're holding out for larger figures. Also problematic and attack on third-party litigation funding is there's no practical way to get permission from all of these plaintiffs that they aggregate together in a lawsuit. So there's a question about whether or not these plaintiffs are really consented to a third-party litigation funder really driving the bus in their litigation. Lastly, what you'll see is an increased volume of litigation in jurisdictions that are favorable to third-party litigation funding. And I don't mean to be depressing, but I wanted to share with you some of the results of the 2023 Litigation Finance Survey Report. And this talks about how far litigation funding has come. Of the attorneys who have worked with third-party litigation funders, 81% would use litigation funding again, and 85% would recommend litigation funding to others. More than half of the litigators, that's 52%, had firsthand experience with third-party litigation in personal injury and mass tort areas. Business litigation was a distant second. The drivers seeking litigation finance were actually the clients at 60%. That was the overwhelming impetus for engaging a third-party litigation funder. The three of these do not bode well for the future. That means you are going to probably see third-party litigation funding expand. And I am cognizant of the fact that I've given you nothing but bad news. I will say there's a little silver lining. There are two larger third-party litigation funders. One is Burford Capital and Juridica. Both of them have said they will not fund class actions or mass torts. So that may be the only silver lining. But the others, basically, third-party litigation funding is available. The terms and conditions vary depending on the type of case.
Okay, I think then our next topic goes back to Katie, and that's personal jurisdiction.
Yes, thanks, Andy and Sonia. So we're going to talk briefly about personal jurisdiction, including a new case that came down from the U.S. Supreme Court in June of this year. And personal jurisdiction refers to the power that a court has to make a decision relating to a party being sued in the case. And before a court can exercise power over that party, the U.S. Constitution requires that the party have certain minimum contacts with the forum state in which the court sits. So first, we're going to talk about a few pivotal U.S. Supreme Court decisions that came down a few years ago. And these cases clarify the limits of personal jurisdiction, which continues to be a significant foundational issue in drug and device litigation. And so these cases provide ammunition to defend against litigation tourism. The first case is the BNSF Railway versus Tyrell case, which was decided in May of 2017. And this case addresses all-purpose or general jurisdiction. The case involved claims brought by two separate employees under the FELA, which is the Federal Employers Liability Act. And the claims were brought by plaintiffs in Montana State Court. The plaintiff employees didn't live in Montana. They weren't injured there. Their employer, BNSF, was not incorporated there, nor did it have its principal place of business there. However, the Montana Supreme Court found that the exercise of personal jurisdiction was proper. The U.S. Supreme Court reversed, and in an 8-1 decision, Justice Ginsburg, who wrote for the majority, made it clear that if a defendant is not, and using air quotes here, at home in the forum state, then general jurisdiction is not appropriate. And the court defined at home for purposes of a corporation as the the place of incorporation, or its principal place of business. So the court said that the focus is not so much on the extent of a defendant's contacts in the state. The court acknowledged that a corporation can operate in many places, but cannot be considered at home in all of them. So this case struck a blow against forum shopping plaintiffs with respect to general jurisdiction. The remaining cases on the slide deal with specific or case-linked jurisdiction and are the court's attempts to clarify the contours of specific jurisdictions, sufficient minimum contacts test. And any attorneys on the call listening probably remember this from civil procedure, goes back to the international shoe case. These cases collectively have emphasized the court's position that special jurisdiction depends on the relationship between the defendant, the forum, and the litigation. And so geometrically, this creates the triangle that you see there on the slide. So in Walden versus Fiore, the court considered the left side of the triangle, the connection between the defendant's conduct and the forum. In this case, the defendant, a Georgia police officer, seized cash from Las Vegas poker players on a layover stop during a flight from Puerto Rico to Nevada. And the players sued the officer in Nevada for wrongfully seizing their cash. The court held that even though the officer may have known the poker players were from Nevada and that they would have suffered harm in Nevada from not having access to their cash, Nevada could not exercise personal jurisdiction over the officer because his conduct was not sufficiently connected to Nevada. The court stated that defendant's conduct must be connected to the forum state by more than just a plaintiff's connections. Rather, the connections must be created by contacts that the defendant himself creates with the forum state. In June of 2017, less than a month after the BNSF case came down from the Supreme Court, the court again turned its attention to specific jurisdiction in the Bristol-Myers Squibb versus Superior Court. And this time the court was considering the right side of the triangle, which is the relationship between the claim and the forum. The claims in this case belong to non-California residents who joined a mass tort action in California against BMS. And BMS was the manufacturer of the drug Plavix. BMS was not incorporated in California. It didn't have its principal place of business there, but it did do a significant amount of business in California, including a high volume of sales of Plavix. But it didn't manufacture the drug there or develop the drug in California or seek regulatory approvals there. The non-California plaintiffs did not buy Plavix in California. They didn't ingest it there, and they didn't even allege that they were injured in California. The California Supreme Court applied what's called a sliding scale approach to jurisdiction and found that specific jurisdiction did exist. But the U.S. Supreme Court expressly rejected this approach and emphasized that the focus really should be on the connection between the plaintiff's claims and the forum rather than defendant's contacts with the forum. Interestingly, the plaintiffs in BMS attempted to use contracts that Bristol-Myers had with a California-based distributor, McKesson Corporation, as a basis for personal jurisdiction in California, and this was expressly rejected by the court. This was another 8-1 decision, and this time Justice Alito wrote for the majority, and the court held that specific jurisdiction requires a connection between the forum and the specific claims at issue, and that defendants' unrelated contacts with the forum are irrelevant to the specific jurisdiction analysis. So BMS struck another blow against non-resident plaintiffs and litigation tourism. Finally, for this screen, in March of 2021, the court completed its triangulation of specific jurisdiction with Ford Motor Company versus Montana and considered what conduct was related enough to the claim to count for purposes of a minimum contacts. So Ford resolved two separate cases, one case in Montana in which a Montana resident died after an accident while driving her Ford Explorer in Montana. And the other case was in Minnesota, in which a Minnesota resident was seriously injured in an accident in Minnesota involving her Ford Crown Victoria. Both plaintiffs sued Ford in their home states, and Ford is incorporated in Delaware and headquartered in Michigan, and moved to dismiss both complaints for lack of personal jurisdiction. The evidence in the case revealed that Ford had directly targeted the states with marketing efforts and dealerships in the state, and there was no dispute that Ford did substantial business in both of the states. Nevertheless, Ford argued that the courts lacked personal jurisdiction because Ford did not design, manufacture, or sell the particular vehicles involved in the accidents in the forum states. The Supreme Court disagreed, and Justice Kagan wrote for the majority and reiterated the modern trifecta that personal jurisdiction depends upon the connection between the claims, the defendant's conduct, and the forum state. The court quickly dispensed with the left side and the right side of the triangle and focused on the base, and was Ford's conduct sufficiently related to the claims at issue. The court answered yes and held that in cases involving, in these two cases involving resident plaintiffs, that a court could take personal jurisdiction over the claims that arise out of or relate to the defendant's forum conduct. So how have courts around the country been applying these rulings? We've seen several applications since mid-2021, a few of which are listed here on the slide. And we don't have time to go over all of these cases in detail, but a majority of the cases have found no personal jurisdiction to exist. One of the most recent cases was the Yamashita versus LG Chem case, which came down from the Ninth Circuit in March of this year. And in that case, the District Court of Hawaii dismissed claims against LG Chem for lack of personal jurisdiction, and the Ninth Circuit affirmed. In Yamashita, a Hawaii resident alleged injury from a lithium battery, and that they alleged that the battery malfunctioned within another consumer device. None of the defendants were at home in Hawaii, so really specific jurisdiction was the issue in this case. Unlike Ford, the resident plaintiff here was unable to establish defendant's conduct supported specific jurisdiction, and the Supreme Court's admonition of this, this was significant with the application of Ford and the Supreme Court's admonition in Ford that the opinion does not mean that anything goes. I want to go ahead and jump to the recent Supreme Court case. So if I can have the next slide, please. Mallory versus Norfolk Southern Railway came down on June 27th of this year. And in Mallory, the court addresses a statutory scheme that treats registration to do business by out-of-state corporations as consent to jurisdiction in the state's courts for all lawsuits, regardless of their connection to the state. And just to give a brief background here, plaintiff Mallory worked for Norfolk Southern Railway for almost 20 years in Ohio and Virginia. He was a carman, and he sprayed boxcar pipes with asbestos foam, and claims he was also exposed to asbestos and other carcinogens in the paint shop. And he was diagnosed with cancer, and so he sued Norfolk Southern Railway under the FELA again, and for negligently failing to provide a safe workplace. Mallory resided in Virginia, and Norfolk Southern was a corporation incorporated in Virginia with its principal place of business in Virginia. and Mallory's exposure occurred in Virginia and Ohio. Nonetheless, Mallory brought his case in Pennsylvania. Norfolk Southern moved to dismiss for lack of jurisdiction, and the trial court found no specific jurisdiction in Pennsylvania, and plaintiff, of course, appealed. So the Supreme Court of Pennsylvania affirmed and held that Pennsylvania's consent by registration statutory scheme was unconstitutional. And in its opinion, the court specifically stated that if every state had a regime like Pennsylvania's, every national corporation would be subject to general jurisdiction in every state, which is an unacceptable result. The U.S. Supreme Court reversed and remanded, and writing for the court in some sections for a group of 4 justices, Justice Gorsuch held that Pennsylvania's consent by registration statutory scheme did not violate due process. And we don't have time today to dig into all of the details of the opinion, but there are concurring opinions and a dissent. And the big takeaway from today is that Mallory blesses statutes that condition foreign corporations and privileges of transaction in state businesses on their consenting to general jurisdiction. And here we have our final poll question, how many other states have a consent by registration similar to Pennsylvania's? And we'll give that just a second for everyone to enter their responses. And we have the results, which most of you say 0, which is the correct answer. And that is the good news coming from this presentation today. So while Mallory appears to be a narrow ruling interpreting Pennsylvania's statutory scheme, there is considerable discussion in concurring opinions and the dissent about how Justice Gorsuch and the 4 other justices reached their conclusion, which may have a broader effect on personal jurisdiction. And some of the effects, as you can see on your screen, are increased litigation tourism in Pennsylvania, changes to other states' business registration regimes, and we've already seen some plaintiffs groups lobbying other states to try to get them to change their statutory requirements. And then the viability of other recent decisions on jurisdiction. And with that, I will turn it back over to Andy.
Thank you, Katie. We are getting close to the end here. So the next topic that I'm going to go through fairly quickly are our FDA updates. So I'm going to talk to you about 4 what I'd call noteworthy updates, off-label communications, and that's a draft guidance as well as a draft guidance related to 510Ks. I want to talk to you about the mifepristone ruling, which interestingly enough had a significant update literally a couple hours ago before we started our presentation. And then I will end with, I think, a topic everybody hears about in a whole bunch of different forms these days is cybersecurity. So to talk to you first about the off-label communication, this is a draft guidance. It's a draft guidance that updates a draft guidance from 10 years ago. So the FDA is obviously not moving very quickly towards a final ruling on this. And it's focused on scientific and medical journal articles and clinical reference resources that are distributed by life sciences companies related to their products. I will encourage you to read it in full if this is something that you're interested in your kind of day-to-day, because I'm going to try to do it justice here, but certainly the actual guidance and the articles about it are the best source here. But in short, the FDA is kind of expanding the permissible scope here, and that these types of things can be shared, but they're placing some limitations on there, primarily that one, these journal articles or whatever you're using are presented in a neutral format and that they have some scientific validity. And though what I read about this particular guidance, this was not specifically mentioned, but I feel like where they're talking about scientific reliability is something a little bit more than those who follow the opioid litigation. A lot of the promotion of opioids being non-addictive came from I think it's a 5-sentence letter to the editor essentially in the New England Journal of Medicine. So to use that to create this whole marketing scheme is, I think, probably what the FDA is avoiding, but they're not going to forbid companies from sharing things that are generally more accepted and vetted within the scientific community. The second guidance I'll talk to you about is the 510K guidance. And this sets best practices, or I sort of love this, they call them recommendations for selection of predicate devices. This, again, it's draft, so it's not final, but the FDA is trying to narrow the devices that can be used in the 510K process as predicate devices, and they're trying to modernize this. So these best practices have a few things that they're looking for. They want companies to be using the most modern available predicate. If it's a product that you're using as a predicate device that's had its own issues with respect to design, or it's been removed from the market or been found to be adulterated or misbranded, you're not supposed to use it. And what I think could be, if this part came through, the most significant is they could also potentially require folks using the 510K process to show why their product is safer or more effective than the predicate device, which is kind of an interesting commentary on free market capitalism. If you're basically having to show that your product is better than the one you're relying upon. So then we'll move to the mifepristone. This is something where I will talk to you about this more in kind of the legal aspects, which I find interesting, because I'm certainly not going to get into the fact that mifepristone, for those of you that don't know, is an abortion drug. So certainly we're not going to be offering any political commentary here today. But this is significant in that for those of you that may have followed this in the news, the trial court in Texas overruled the FDA's approval of the drug, which had happened, I believe, like in 2001, roughly 20 years ago or a little bit more. And it's the first time where a court attacked and essentially overruled the FDA's scientific judgment. So this went up to the Fifth Circuit. The Fifth Circuit overturned part of the ruling, but not all of it. And really, it overturned the part related to the initial approval of the drug in the early 2000s, saying that that type of challenge was time barred. And then just today, I saw a headline that the Supreme Court has agreed to take up this case. So this is going to be an interesting ruling, both, I guess, for the political purposes, but also for kind of the FDA piece, in terms of if private litigants are able to attack the FDA's scientific rulings and judgments, what does that mean moving forward, in terms of both, I guess, like advocacy groups and other kind of competitor companies trying to scuttle things in that regard. The final thing I'll talk to you about is cybersecurity guidance. The FDA was given increased authority to to regulate cybersecurity in the Consolidated Appropriations Act of 2023. And so this guidance actually came into force this year. And I believe as of October 1st, it's something that has to be complied with in the PMA process. And again, if this is something that you deal with, I would say look at the entire guidance and kind of the news out there on it. But it's requiring devices to be secure by design, that this cybersecurity is something that you're going to have to show in the pre-market approval process. And what could be take the most effort for companies is that there needs to be a post-market cybersecurity surveillance program in place, which would include patches and updates and things like that. As you know, this is an ever-evolving world, right? So if your product is cyber secure as of 2023, when it's approved by the FDA, you're expected to make sure that that's the case for the entire life cycle of the product. So with that, that is kind of the end of the content that we have here. We have like 3 minutes. So Kate, maybe one question?
Sure. One that did come into us, I think would be directed to Sonia. We received a question about legal funding. How readily available is third-party legal funding, and how does it work? Where does it come from?
It is readily available for a majority of cases, but the terms of the money vary. It may have a higher interest rate, have more stringent terms. The money comes basically from hedge funds. A lot of the third-party litigation funders are started by hedge funds, and they've realized enormous profits from it.
Thank you. Andy, we have one other question as well. With regard to jurors, do you think that the safety-ism and conspiracy theory influenced juror? Is that a permanent shift?
Unfortunately, I think the answer to that is yes. If Sonia had any commentary, I'd be interested in that as well. But we've been seeing this trend kind of in trials that we've had and mock trials we've conducted on our claims, and this trend has been going on for years, at least 5 to 6 years, and I don't see it really changing. Hopefully, the industry and kind of the defense bar becomes better able to deal with these types of jurors and figure out ways that we can convince them that they don't always have to rule for the plaintiff.
Andy, I do agree with you. It is a bad place to be right now. And, no product can be without risk. Well, that's not the equation in defending pharmaceuticals or medical devices. The benefits have to outweigh the risks. There is some risk in everything that you put in your body that wasn't there to begin with. And so if you're saying any risk is unacceptable and calls for a recall or calls for some liability, then we're in trouble as an industry.
Are you seeing any difference between over-the-counter versus prescription products in that regard with the degree of risk, evaluating risk? Is there more, or is there as severe a reaction from jurors when it's the doctor's responsibility to evaluate those risks? Or are they still expecting 100% risk-free?
Yeah, yield to you.
Yeah, I would say my experience would be more on the medical device side than the pharmaceutical part of the question. I think doctors are not as sacrosanct as they were pre-pandemic in terms of jurors finding fault with their actions. We've seen that as well in some of our more recent claims and mock trials and trials. Doctors that are not reading guidance provided by the company or cutting corners, we've seen jurors react really negatively to that. That said, typically in those scenarios, the jurors are still hesitant to totally let the product's liability component completely off the hook. Even if the ire is not directed towards them as much. So I think that hostility to the industry is kind of regardless of, prescription versus over the counter, whether, and kind of the same with medical devices.
Just a really challenging environment all around.
Unfortunately, yes.
Yeah. Well, on that happy note, Sonia, Andy, and Katie, thank you very much for your time today. Claims are always front of mind for our audience, and we know this information will be valuable to them in preparing for the year ahead.